NCLAT says to our minds, the appellant had clearly failed to discharge their obligations to lodge claims within prescribed time limit. In these circumstances, we are inclined to agree with the respondents that allowing belated claims of the appellant will open floodgates of the multiple such claims. This has been held by Honorable NCLAT Principal Bench, New Delhi, on 1st May 2025 in the case of DSP Asset Managers Private Limited versus Grant Thornton India Bharat LLP, and it was the judgment by Justice Ashok Bhushan. The parties involved in this case was appellant DSP Asset Management Private Limited, respondent number 1 Grant Thornton, who were appointed the claim management advisor, respondent number 2 Infrastructure Leasing and Financial Services Limited, the corporate debtor classified as red entity under Government of India appointed board since 1st of October 2018. Provided unconditional, irrevocable corporate guarantee to IL&FS Transportation Network Limited, in short, ITNL. ITNL, in fact, was the company where this IFSL has given the guarantee to NCD, and that is what is the dispute. And respondent number 3 was the IDBI trustee, and they were appointed as trustee to the NCD or debentures. In 2016, NCD was issued, total 7,800, having a face value of 780 crores. It was issued, and it was subscribed by DSP. It was subscribed by DSP Mutual Fund, and the parent guarantee was given by IL&FS Limited, and the debentures were issued by ITNL. So the parent guarantee, the entire dispute is on parent guarantee, and the maturity timeline was that the NCLTs were, in fact, it was supposed to be matured in September 22, and the trustee IDBI was appointed in this case. And when this ITNL defaulted in September 2018, and therefore the default triggered the guarantee obligation. Default triggered the guarantee obligation of IL&FS. In the meantime, IL&FS group, in fact, had a financial collapse, and owing to the widespread defaults and financial collapses across IL&FS group, the Union of India filed a petition under Section 241 and 242 of the Companies Act seeking supersession of IL&FS board. And in October 2018, the board was superseded and appointed a new government-nominated board. And in October 2018, a kind of new framework was decided by NCLT. It was a group resolution framework. A unique group resolution framework was approved by NCLAT wide order dated October 2018, treating IL&FS and its 300 group entities as part of a consolidated resolution. This framework was outside the scope of standard CIRP, and followed a reverse CIRP style approach involving asset monetization, claim verification, and interim distribution. However, later on, it was held when this judgment was passed that this particular framework is akin to resolution. It is akin to CIRP. And therefore, in this entire process, the claim management was given to Grant Thornton India LLP, and they issued first public notice, then multiple extensions were also given. So the DSP partial claim was filed. So they filed partial claim. However, they missed filing the claim on the parent. The IL&FS provided the guarantee to the NCD. So they missed filing this particular claim to IL&FS. So therefore, they submitted a belated claim in June 2023, and it was rejected by Grant Thornton. And finally, the NCLT application was filed, NCLT also rejected it only because DSP had prior knowledge of this process. They filed partial claims. They did not file the claim on the parent entity for against the grantee, and therefore admitting claims at such a time when this some part of the distribution to the stakeholders have already happened. So therefore, this was dismissed. NCLAT appeal against the order of NCLT, DSP filed that appeal. DSP argued that it is a grantor's liability. They said that the IL&FS had given grantee and it is their liability. Then the justification of delay was also given. The legal precedences in various cases like Rainbow was also given. And then they said that it is the responsibility of the debenture trustee, not ours. And therefore, they were saying that it is actually impacting the retail investors of DSP. However, the books of account argument was also given in the case of the 𝐾𝐬𝐬 developers. That was also given. However, the respondents said that DSP had prior knowledge, and it is not only the debenture trustees' prerogative to file or obligation to file the claims, it is also the responsibility of the applicant, and the resolution is at advanced stage. This is extreme delay. There is no reasonable cause for the delay, and therefore it is not possible because it will disturb the entire resolution process. And the key issues that NCLAT handled, whether the belated claims can be accepted, what is the role of the trustee. So in fact, the timeline, the nature, and the equity principles, everything was in fact decided by NCLAT, and it was very clear that Section 241 of the Companies Act, application to the tribunal for relief cases, and Section 242 is the power of the tribunal, and Section 421 is the appeal for orders of the tribunal. And it is also said that this resolution was kind of akin to CIRP, and therefore Regulation 12 of the CIRP would also be applicable. And then the judgment, in fact, relied upon 𝐾𝐬𝐬 developers and the Acer Steel. All these judgments were relied. And finally, what I said originally, the NCLT said, to our minds, the appellant had clearly failed to discharge their obligations to lodge claims within prescribed time limit. In these circumstances, we are inclined to agree with the respondents that allowing belated claims of the appellant will open floodgates of multiple such claims. If belated claims are allowed for any specific party, there is all likelihood from other similar placed claimants to seek reopening of the claim window, leading to the need of remapping of the creditors and pro rata revision, and therefore it is not possible, and the claims were in fact rejected. There is no reason. The appellant had not provided any cogent reasons for delay in filing the claims, despite multiple extensions of the claim window having been allowed. So therefore, the adjudicating authority has not committed any error in the given facts and circumstances. In fact, this judgment is also kind of corroborating with many other judgments in insolvency. Any claim which is much delayed, now of course there are some relaxed provisions are there. The relaxed Regulation 12, where the RP is under obligation to seek condonation for all those claims received before the voting of on the resolution plan starts. But this judgment is also confirming that the filing of the claim on time is must. Thank you very much.